Hey, Mallory. Good to see you again.
Hello.
Today, I wanted to talk about failure to diagnose cancer. These are cases that we've been seeing in our office recently. And I just kind of wanted to go over some of the pitfalls, some of the things that would allow these cases to succeed. And then one of the main cases on this type of failure to diagnose, which is Herskovits.
Yeah, let's do it.
Yep. So the first thing is, can you tell us a little bit about some of the cases that we've gotten in recently? Maybe not the specifics, but just kind of generally what those cases are about.
Yeah, so I see this a lot where someone has symptoms that would raise concerns for cancer, a tumor, a lesion of some kind that doesn't look right, that should be looked into, but for some reason it gets missed. So there's very many different types of cancer. We've seen this happen with a nodule on the lung that, they failed to scan early enough to catch the cancer as it grew, and then it grew, twice the size by the time they caught it, that kind of thing. And then by the time they catch it, it's at a stage where it's much more difficult to treat, right? Cancer can spread very quickly. And so it can go from stage 1 to 2 to 3 to even 4 very quickly. And so timing in these cases is really crucial. And so we see cases a lot where even a matter of months makes a huge difference.
Yeah. And a lot of times, these cases, like the doctors, there's certain risk factors of the patient when they come in. And if there's, maybe two or three risk factors put together, then the doctor should either do either some testing of some kind or some imaging of some kind or maybe a biopsy. And they don't end up doing that. They just say, well, come back and we'll take a look at it in 2 months. And,
Right.
maybe based on either certain guidelines or national guidelines or just the common practice in the area, the doctor should have been more aggressive about trying to figure out whether or not cancer was there.
Yeah, absolutely. And there are very specific guidelines for different types of cancer and how to monitor that. Certain types of scans every 3 to 6 months for the first 2 years, those kinds of very specific guidelines that doctors are supposed to follow. So when those aren't followed, it's a big issue.
Yeah, and that's kind of just the first hurdle, really, is proving that there was a deviation from the standard of care. The
Yeah. And that's,
bigger hurdle,
yeah, that's
yeah,
typically the easiest hurdle to overcome, right?
yeah,
Because it's very clear what the guidelines are and whether there was a breach.
yeah, and even there, what we'll see is we'll see a pretty big battle on that as well. But really, the bigger battle is on causation,
Right.
which is not an easy concept. Even if you're a lawyer, it's not an easy concept to get through because there's proximate cause and then there's cause and fact. And then there's these probabilities, like on a more probable than not basis or to a reasonable degree of medical certainty. What does that mean?
Right.
Yeah.
Well, and in these failure to diagnose cases, it's even more complex than a typical case because we've got this uncertainty about what would have happened if we had caught this sooner. And that's so tough to determine. It's
Yeah.
sometimes impossible to figure out what stage would the cancer have been at if we had caught it 3 months earlier. And that is, it really impacts just whether you can prove causation. And it's hard to determine that.
Yeah. And generally, for civil cases, causation is more probable than not, which is 51%.
Right.
Eh, But when a doctor's actually testifying, the language that they use is important. And what they need to say typically is more to a reasonable degree of medical certainty, which is equivalent to more probable than not, but it doesn't sound like it.
Right.
Yeah. But getting an expert to testify to that can be difficult because they're essentially saying that in some ways they're predicting what would have happened, which is very difficult.
Right.
Yeah. And then in these cases in particular, like in Herskovits, which is, we're going to be talking about that in detail, but he goes in December 1974 and he has a really aggressive type of lung cancer. And even at that time, even if they diagnosed him then, which they did not, but even if they did, he still had under a 50% chance of survival at that time. What was it, like 39%?
39%, I think, yeah, was what the expert testified.
Yeah, so they didn't end up diagnosing him, even though the argument is they should have diagnosed him with cancer then. But if he has only a 39% chance of survival, then he would never meet that 51%, more probable than not, that the failure to diagnose the cancer or the negligent failure to diagnose was the actual cause of his death, where he dies 20 months later.
Right. And that comes up so often in these cases, as you can imagine. Oftentimes, when people are diagnosed with cancer, there's a very low chance of survival. And it's a matter of, and then in Herskovits, which we'll talk about, there's a huge discussion of the policy repercussions of making a decision on this, because if it's true that these people can't have a cause of action unless their survival rate is 51%, then there's a huge category of people who just would never be able to bring a claim no matter what kind of negligence was done in their care.
Yeah, which is part of the reason why we have our tort system is to monitor the different industries so they can't just go and perform negligent acts without some sort of repercussion or without making good on their wrong.
Right.
And in these cases, if you were going to die anyway, or you were likely going to die anyway, then it's like none of these people would end up getting punished is maybe not the right word, but
Hold
reprimanded,
accountable.
held accountable. That's the
Yeah.
perfect word. Yeah.
Yeah, because it makes sense that the hospitals we know are understaffed and have a lot to worry about, and so it makes sense that if there's not some kind of external accountability, that these people with the who really are the most vulnerable people and most need of urgent medical care could get dismissed and shoved under the rug if there's no accountability for their treatment,
Yeah.
if they're likely to die anyway.
Absolutely. So in these failure to diagnose cancer cases, from the lawyer point of view, where we normally start is consulting an expert. Normally we go to ChatGPT first and we try to
Yeah.
see if we can find a quick answer or at least a direction. But
Mhm.
then our next step is typically getting an expert involved. And there's really two different type of experts in these medical malpractice cases. One is a merit review expert, and then the other one is actually a testifying expert. So can you talk about the two?
Yeah, so typically for a merit review expert, we're looking for something a little bit less formal. This is early stages of the case, so we're trying to find someone who's maybe going to do this for a little bit more cheap than a testifying expert. Testifying experts can be very pricey, and if it's a case that we're really just not sure about the medical side and whether it's viable yet, we don't want to spend so many resources. And often we're asking the client to help us pay for this. And so we don't want them to spend a bunch of resources just to figure out whether they even have a case. So we're finding someone who is willing to do this for a little bit more cheaply, but probably has a lot of experience, has seen a lot of these types of cases, right? You want someone who has worked in this field and can tell you what the standard of care is generally and whether this is likely to be a breach and whether the causation is likely to be there.
Hmm. And so these merit review experts, how much do they typically cost? And how long does it typically take?
Yeah, it depends on the type of expert. So it can be anywhere from an initial review. It also depends on how many records there are, right? So how much time this has been going on for could be anywhere from $500 to a few $1,000s. And the review can, I would say, depending on how quickly we can get the materials to them, because the experts are obviously reviewing the medical records that we receive from the client. So depending on how quickly we get those materials to the expert, they can probably get it back to us within a week or two, usually.
Yeah. But generally, in my experience, when you initially talk with a potential client, to the time that we get them to a merit review, if they decide to go that direction, could be 3 months.
That's true. We're doing a little bit of our own research before we get to the merit review stage. So by between the time I initially have a conversation with someone to the merit review can be a few months, a few weeks
Yeah.
to a few months. Yeah.
Yeah. And part of the reason for that is number one, we need an accurate timeline and an accurate story. And a lot of times we need to actually review the medical records. And so A lot of times the potential clients, they don't have a full set of medical records. They might just have one record or a couple records or just
Hmm.
from one particular hospital. But sometimes there's like doctor's notes that we need to fill in the blanks and some prior history.
Right.
And getting those records doesn't always, not always easy.
No, it's not. It'd be quite confusing, especially because it's easier, typically easier, cost effective for the clients to get those things themselves. But I'm walking them through that, and that can be
Yeah.
tough. So, yeah, it does take some time to gather those things. And then, of course, always review the records before we send it off to a merit review expert. Because before we pay someone else to do it, I want to take an initial look and make sure there's not something glaring that's going to be detrimental to the case. Because
Yeah.
sometimes clients misremember certain facts or appointments and what the doctor said, or it looks different in the medical record than what they're explaining to me. And sometimes there's just a couple of little tidbits in the medical history or something that the client didn't think to mention because they didn't think it was relevant. But as I'm researching, I realize, oh, this is going to be a huge deal.
Yeah.
So
And then even after that, we have to actually find an appropriate merit review expert.
it can be tough.
Yeah, depending on we do see similar medical malpractice cases, at least similar fact patterns over and over again, but they're always a little bit slightly different. So, like in a failure to diagnose cancer case, a failure to diagnose breast cancer is going to be a totally different expert than failure to diagnose colon cancer. Wouldn't use the same type of expert on that.
Absolutely. Well, and I think that also matters a little bit differently in the merit review stage versus the trial stage, right? For trial, we obviously want to get someone who's really an expert in the exact field. For the merit review stage, I'm thinking about getting an expert who obviously I'm not going to look for a breast cancer expert for a lung cancer case, right?
Yeah.
But there's a little bit more wiggle room, I would say, with, for example, there's experts who like specifically work on surgical oncology versus medical oncology. And that might be a distinction that's more important for a testifying expert, but at the merit review stage, a surgical oncologist might still be able to give me a good sense of whether there's a case here. If they could do it for cheaper, I might have them review the case a little cheaper on the front end, even if they might not testify for us.
Yeah. And
Yeah.
we've had situations before where we get the merit review, whether it's just a verbal conversation or it's in writing, and they say that there is a breach in the standard of care. But sometimes that's not enough because then we go on to the causation piece. And then finally, we go on to the damages piece.
Right.
All 3 they could require all 3 different experts. Sometimes they're the same, but sometimes you need 3 totally separate ones, and depending on what a causation expert would say and a damages expert would say, that could affect whether or not we wanna take on the claim.
Right. Absolutely. Yeah.
And in addition to that, sometimes the merit review, because they're not necessarily reviewing 100% of the medical records, their opinion can change. Like I remember doing an arbitration where we had somebody do the merit review, was very strong on the merit review, but by the time we got into arbitration, he was testifying. He really kind of went back on a lot of different things. And so he was not a good testifying expert. And they're
Right.
two totally different people because the merit review could just be a pure academic. But the testifying expert, that person actually has to have a little bit of charisma.
Hmm.
Their communication skills need to be excellent. So they need
Yeah.
to be able to dumb it down in such a way where they can tell the jury in a story format that's very easily digestible, which is
Right.
sometimes pretty difficult to do. That's a skill in itself that
Yeah.
doesn't necessarily have to do with their expertise in the medical profession.
Yeah. And there's also some level of understanding the basics of the legal framework here when you're a testifying expert, right? Because you need to be able to say, with a reasonable degree of medical certainty and be confident in that, but not be overconfident to the point where you're saying things that you can't possibly know. So
Yeah,
there's a little bit of nuance there too in understanding the legal framework as a testifying expert, which we don't necessarily need from a merit review expert.
absolutely. And withstanding a really good cross examination, that is an art. Some people are really, really good at that,
Yeah.
and some people are terrible at it. But
Mhm.
they could both have the same qualifications. But obviously, when we're putting on a trial, it's like putting together a film or a movie, and we're the directors of it. So when we hire particular actors to, in this case, it would be expert doctors, we want to make sure that they're telling the correct part of the story. That's
Absolutely.
really important.
Mhm.
In the case of Herskovits and failure to diagnose cancer, can you tell us a little bit about that case and how that came about?
Yeah, so as we mentioned, this was a case where someone was diagnosed late with lung cancer. So they had symptoms and probably should have been diagnosed, at least according to the plaintiff's expert, should have been diagnosed about 6 months before they actually were diagnosed. So there was a 6 month delay there. And that was a decrease in the survival probability, which this expert framed this as a 5 year survival probability. It went from 39% to down to 25 by the time it was diagnosed. Obviously, the issue here that the court was looking at was whether this claim can be maintained and can survive summary judgment, where they can show there was a substantial measurable decrease in the probability of survival, but it was still less than 51% regardless. The issue is this sufficient basically to submit to a jury and let them decide whether this was caused by the defendant and what the damages would be.
Yeah, so at the trial court, I believe they lost, correct? And then
Correct.
they
It was
appealed.
dismissed on summary
Yeah.
judgment, and so plaintiffs appealed, and this was basically they're saying, "We believe we have enough evidence to move forward to the jury." Yeah.
Yeah. And so with these summary judgment cases, they don't even go to a jury. So they get
Right.
decided. So you file a lawsuit and you allege that the failure to diagnose the cancer timely was the cause of Herskovits's passing away. And you file that complaint and you go into discovery. And then the defense makes a motion saying that, okay, just let's even assume that there was negligence. We're not going to agree to that, but let's just assume for argument's sake that he should have diagnosed it then. The defense is saying even if that were the case, there's still no case here because you cannot prove that there was more than a 51% chance that he would have survived even if he was diagnosed on the day that he first came in. So you lose as a matter of law. We don't even need to go forward from here. We don't need to go to a jury. This could be decided right now by the judge just in oral argument or even
Right.
in written argument. And it deprives the plaintiff from his or her day in court to
Right.
present it to a jury. And that's a huge right in this country, the right to a jury trial. And
Mhm.
when we're going into a summary judgment motion, it presumes all the facts and the most favorable to the non-moving party, which means that's a lot of legal terminology, but what it really means is the defense, if the defense is asking the judge to summarily dismiss the case, then the judge must assume that all the facts that the plaintiff is presenting are essentially true.
Yeah, so basically assuming the expert is correct, that they are accurately estimating that the percentage chance of survival was 14% difference. The defense is basically saying, even assuming that, we did not cause the death because the death was inevitable.
Yeah.
Yeah.
Yeah, and that obviously was a problem in Herskovits because they took it up on appeal and it went to the Supreme Court. And in 1983, the Supreme Court overturned that summary judgment ruling and said that there was, in fact, some damage. And that damage was the loss of chance from going from a 39% survival rate into a 25% survival rate. And so the total differential or the delta would be 14%. And that 14%, I guess how you would calculate or how you would make an argument to the jury how to calculate what that 14% would be worth would
Right.
be total up the value of the death for the wrongful death and take that total value and then you multiply it times 14% and that would be the damages.
Yeah.
Yeah. So there was also an interesting concurring opinion that tell me what you thought about that, and I'll tell you what I think.
Yeah, so Pearson wrote a concurring opinion that I thought was really interesting. It got very in the weeds about the issue of what the actual damage is here, whether it is the death the actual injury, and if so, then it was not caused by the defendant's negligence, but if the injury is the loss of chance itself, then that is the concurring opinion is, yes, I agree with the conclusion, but they just didn't agree with the way the court got there. They didn't I think that Pearson didn't like that the court relied so heavily on the policy side of it. And so Pearson takes a much more detailed, logical approach to figuring out how do we actually quantify what the damage is and all of that. I thought it was very my initial reaction was that it was very existential and sort of philosophical in a way that was a little bit abstract for me, but I think in the end, it actually did get to the heart of identifying the importance of identifying what the actual damages are. Because if the death was more likely than not going to happen either way, then the damage really is that 14% difference
Yeah.
in the chances
I
of
actually
surviving.
liked the way that because that's one of the parts that I was struggling with even in the beginning of understanding the loss of chance. And the way that Pearson laid it out, it made better sense to me that you first need to identify what the injury is.
Right,
And if the injury you're claiming is death, that because group health did not diagnose the cancer on the December of 1974, and they should have, that their negligence caused his death. That doesn't make sense to me because he only had a 39% chance of living anyway. So it
right,
didn't necessarily cause his death. He was probably going to die no matter what. And
right,
for our standards for civil cases, it's more probable than not. He's more probably than not going to die. So that doesn't make sense to me. But if you identify the injury as he his chance of surviving got minimized, which is essentially the loss of chance doctrine, then that makes sense to me that on a more probable than not basis, had they diagnosed it earlier, he would have had a greater chance of survival. So that
right.
actually makes sense to me. But the nuance here also, the practical application of it is typically when we file a complaint, we will be filing it because the patient has passed away. We would be filing it under the wrongful death statutes. And, you know,
Right.
that would complicate things in some ways. And I don't know if at the time, there was necessarily a loss of chance doctrine that was there. So,
Yeah, and Pearson discusses that, but I don't know if there was any conclusion about it. But yeah, their opinion discussed the fact that there's a question of whether this is even a wrongful death case if the damage is not the death, but rather the loss of chance of recovery.
yeah.
Yeah.
And then one last thing that I wanted to talk about was the in-state versus the out-of-state experts. So we're constantly talking with experts and researching experts and looking for experts and what are your thoughts on the out-of-state versus the in-state expert?
Yeah, I think there's benefits and drawbacks to both, right? For an in-state expert, they are probably more familiar with local practice and patterns, which is important in establishing a standard of care. And they are probably more likely to be trusted by the jury, who's going to be a jury full of Washingtonians. But at the same time, it could be harder to find the sort of specialized expert that you need, right? If you're just looking within the state, a lot of times specialized doctors go to there's specific hubs that they might go to out of state
Yeah, like
to
Stanford
practice,
or
right? Or
MIT
yes.
or you know,
And so if you're looking for a testifying expert who's going to have the specific expertise you need, especially in a case where you need a more specialized expert to talk about this particular issue, which cancer there's a huge amount of studies constantly being done and it's always changing. And so it is really important to get a specialized expert oftentimes. So I do think you're balancing the value of having a more specialized expert from out of state who might have a better time, like you were talking about earlier, convincing the jury and telling the story to the jury in a way they'll understand because they have so much knowledge and experience with whatever the specific type of cancers that we're dealing with versus the more familiarity of an in-state expert.
Yeah, and the in-state experts, part of the issue with that is they know a lot of the other doctors in the field. So,
Yeah,
especially if you're getting a surgeon who works on plastic surgery, well, all the plastic surgeons, they all know of each other. So, if they're going to be testifying against one of the plastic surgeons, they, immediately are going to create enemies inside of their own field. Nobody wants to
right.
do that. So, finding in-state experts sometimes tough because of that.
Yep,
And like you said, the expertise. There's always this national standard versus local practices issue that comes up. It's not a huge issue, but in order for somebody from Stanford to testify in the state of Washington, they have to essentially say that they are familiar with the standards in Washington,
right.
whether they practiced here and they personally know, or they've talked to one of the other doctors here that has communicated to them that the standard is actually XYZ. Overcoming that sometimes can be a little bit of a hurdle. Typically, it's not, but getting them to have to testify that they know what the local standard is. But anymore, a lot of these medical standards are now national, I think,
Yeah,
just
yeah, it's
because of
true.
communication technology.
And I think the standards that are more localized would not be too difficult to familiarize yourself with, especially if you're already an expert in the field. I was reaching out to an expert recently on a cancer delayed diagnosis case who was already, before we even started doing the review, she was already identifying potential issues with a difference in her practice versus what we might do in Washington. So experts are aware of the differences in the practices in different localities and how that might affect the case.
Yeah. And then if you were to give any advice on these failure to diagnose cases, not just cancer, but any of the other failure to diagnose cases that we get to any of the potential new clients or lawyers who are analyzing these cases, what do you have anything that you would recommend?
I would say just documentation is a huge issue. Get your medical records organized, take your own notes as you're going through appointments if you have suspicions that something's getting missed. Ask for testing. Of course, the more clear the delay in the diagnosis, the better the case. But we would hope that people get diagnosed as early as possible. So if you suspect that this might be happening, I would say get second opinions, ask for testing if you need it, make sure everything is documented well.
Yeah, putting together a well-organized inquiry to lawyers is very helpful. For
Mm.
timelines, help
Yeah.
us do a quick analysis. So we appreciate that as lawyers. If you're
Yeah,
organized,
absolutely.
yeah, you
Have
got
your
your
have your
medical records.
dates. If you had specific appointments that you knew were important to your case, have those dates written down and ready to go. Yeah.
Yeah, and the other thing, which might be hard for some people, but if the potential new client understands this concept, which is to stick to the material facts, because there's a lot of facts out there that you might be upset about or that you think meant something that caused an emotional response, but is not necessarily relevant to the case. That's sometimes
Yeah,
hard to do, but
it's
yeah.
hard. I see a lot. I think the biggest one is doctors failing to inform clients of things until later. Sometimes that's important, but a lot of times it's not as important as you think it is. Of course, you want to be well informed about what's happening, but at the end of the day, what matters is the long-term impact of the doctor's actions.
Yeah. So if the failure to inform would be sufficient for informed consent claim, which essentially not only would you need to prove that he should have told you of the likely dangers, that's going to be in an informed consent document that you sign that you don't even remember signing. But
Right.
not only do you need to prove that it was something material that he should have told you, but you also need to be able to prove that a reasonable person would have decided not to do it once they heard of the risk. And that
Right.
one, that's sometimes really hard to do because sometimes you need a surgery. And yes, there's a chance that there'd be internal bleeding and this and that, but sometimes it's, hey, I still need that surgery. So,
Right.
yeah,
Yeah.
even if you're informed of the risks associated with the reasonable person would typically a lot of times go forward on it. So
Yeah.
sometimes that's not the case, but okay. Well, great. Anything else?
I think we covered it.
Okay, awesome. Thank you again, and we'll see you next week.
Thanks.